Good morning. Welcome to our record keeping workshop. We've got a combination of handful of people who are with us live in person, and we have a number of people who are joining us virtually. So, welcome. I'd like to introduce myself. My name is Gary Glader, and I work with CCIG. I'm a new employee to CCIG, started in December 2021. Been a Colorado resident now for all of a week. Happy to be here from Chicago, and if you look out your window, I think I've brought some of the Chicago weather with me. But this is nothing new to people in Colorado, and it's just something to get used to. So today we're going to talk about OSHA record keeping, and those few brave souls who got here today, driving through terrible weather, all to hear about OSHA record keeping. What an exciting subject we have to talk about today. However, it is an important subject and one that people really need to have a grasp of, because doing it incorrectly can really be costly. It puts you in a bad position. And I usually ask questions, but because we don't have many people here in a live audience, it's a little bit different. But some key questions: true or false? Every workers' compensation claim will always be an OSHA recordable. A lot of people say, well, if it's a work comp claim, then it's going to be an OSHA recordable, but that's not necessarily the case. It may be, but as we're going to learn today, there is a difference between an OSHA recordable and a workers' compensation claim. Another question: my employee was injured and went to a clinic for observation and treatment. True or false? In every one of those situations, a trip to the clinic will result in an OSHA recordable incident. A lot of people think, well, yeah, if they went to the doctor, they went to the doctor. That's going to be OSHA recordable. But the answer to the question is no, not necessarily. So we're going to be working through these things today and learning a little bit more about OSHA record keeping, because it is important. And the one thing I would tell everyone to do is find a reason why an injury doesn't need to be put on the log. If you look at it through that lens and use all the tools, and I'm not telling people to skirt the law, I'm telling people to look carefully at the rules and determine whether or not that incident goes on your log, because too many incidents on the log, as we'll learn today, is a bad thing and can put you in a bad spot. So, my responsibility at CCIG is the safety consulting operation, and I'm happy to be with the company. Been here all of a month and a half, going on 2 months now, but we're looking at doing many more of these workshops that we're doing today, as well as providing additional safety consulting services to our clients. So welcome all of CCIG's clients and prospects to our workshop. Thank you for participating. Probably going to take 1, maybe 2 breaks today. Quite honestly, I just can't talk for that long, so we'll take a little break. But for the people that are here live, anytime you have a question, please ask the question. I'll repeat the question so those that are participating virtually can hear it and answer the question. For those that are participating virtually, there is is it a chat?
Yes, there's a live chat.
Live chat. There's a live chat feature that you have available to you. What I'd like you to do is, when you have a question, use the live chat, and at the end of the presentation, I'll address the questions that have been asked virtually. And actually, that might work out fairly well, because what you may want to do is you may want to hold your questions, jot them down, and then enter them in the live chat towards the end of the presentation, because if you have a question now, there's a good chance that I will address that in the next hour or so and get to that. So this is kind of a combined approach of OSHA record keeping as well as an update to what's going on with OSHA. So needless to say, everybody has been concerned about COVID and OSHA's involvement in that, and there's been a lot of activity. So I'm going to briefly summarize what's been going on. Shortly after we discovered COVID was a pandemic, the agency did get involved, and they got involved early in 2020 once the pandemic had been identified. The best that OSHA could do at the time, really, legally, was to come up with guidance that they issued to employers to prevent or reduce exposure to COVID. Because COVID is everywhere, which means that it's in our personal lives, it also is at work. It's a virus. It doesn't discriminate in terms of where it wants to be present. So it was everywhere, and when it's in the workplace, that is OSHA's jurisdiction, and they addressed it by providing this guidance. So I provided a link. Incidentally, you will have this link live if you wanted to go back. God forbid you want to hear me talk anymore than you're going to have to today anyway. But if you wanted to go back and pick up a point, you can go back to the link and review some of the discussions that we're going to have today. But in the slide deck, you will see a link that will take you to what OSHA's current guidance is for employers. So with respect to COVID, just a brief history of this, because it is kind of interesting. In January 2021, President Biden instructed OSHA to develop a temporary emergency COVID standard. Originally, it was meant to be for all workplaces. And he instructed the agency to do that. Matter of fact, if I'm not mistaken, I think he gave them 2 weeks to do it. And you don't give any government agency 2 weeks to do anything, because it's going to turn into more like 2 months, maybe 2 years, depending on the circumstances. But COVID was a different situation. So in June of 2021, the agency OSHA issued a standard for COVID strictly for healthcare employers. It was only for healthcare and healthcare-related employers. So hospitals, doctors' offices, nursing homes, strictly in that space. And it was an emergency temporary standard. I don't want to get into the details on that, but when OSHA develops an emergency temporary standard, it's in effect for no more than 6 months, because they bypass the normal rulemaking process. When OSHA develops a standard, it has to go through a huge process, a rulemaking process. Well, they couldn't wait that time with COVID, so they used the emergency temporary standard, but that has limitations. So this standard, which was issued on June 21st of 2021 for healthcare, COVID in healthcare, actually expired on December 21st. So that standard is no longer in effect. They can re-up it, but it has to go through the standard rulemaking process, which is going to take a long time. Hopefully, COVID is in our rearview mirror very soon. I mean, I can't imagine anyone is actually hoping that COVID extends out longer than what it currently has. But let's hope it's in the rearview mirror soon. So anyway, following the healthcare standard, the OSHA vaccine standard for employers with 100 or more employees was published on November 5th. That was a big deal, and everybody has heard about the process that whole thing went through. Well, essentially, this is what happened. The standard was issued by OSHA requiring vaccines for all employers with 100 or more employees. Shortly after the standard was published, the U.S. Fifth Circuit Court issued a stay. People filed suit, and they filed suit in numerous U.S. circuit courts. Well, the Fifth Circuit was the first circuit court to say, no, we're going to put a stay on this because it's a federal court. OSHA was not able to proceed with enforcement of the standard. Well, going back, because so many suits were filed in different circuit courts that could all have different rulings, and then what do? The process, and this was a learning experience for me, is when that happens, they actually have a lottery. And all the circuit courts, literally, I don't know literally if they drew a name in the hat, I don't know if they used random number generators, but they randomly selected a circuit court. And that was the Sixth Circuit Court to hear and decide on the stay for the OSHA vaccine standard. And rather than go through a lengthy trial process, the Sixth Circuit Court had a panel of three justices, who determined that the standard was good and that OSHA could go ahead and proceed with the vaccine standard. So the Fifth Circuit said no. Sixth Circuit, not the full court, a panel of three justices, decided that OSHA could proceed. Well, next step in the process is to appeal to the U.S. Supreme Court. So the appeal was made by many different employer groups to the Supreme Court. Justice Kavanaugh is responsible for the Sixth Circuit. Each Supreme Court justice, it was a learning experience for me, has responsibility for the different circuit courts in the U.S. So Justice Kavanaugh has that responsibility for the Sixth Circuit. So he took the appeals on the Sixth Circuit's decision and decided to take the case. So the Supreme Court heard oral arguments from both sides on January 7th of this year. And on January 13th, the court ruled in a 6-3 decision that the OSHA vaccine mandate, this is interesting, likely exceeded the agency's authority. They really didn't decide the merits of whether a vaccine mandate is okay or not. What they decided was, at this point in time, there's not enough information to let it go forward. So it is entirely possible, if the administration continues to push for a vaccine standard, that this could be heard by the Supreme Court. But that is a lengthy process. If that happens in a year, hopefully we're talking about a virus that's long since in our rearview mirror. So the only way that would happen is for the Sixth Circuit to hear the entire case, and even if the Sixth Circuit decides that the standard is okay, it's going to be appealed to the Supreme Court, who's already ruled in a 6-3 decision that it's probably not going to be a proper thing for the government to do. And it's really interesting. So private employers, at least as far as the law that's in place now is concerned, private employers can implement a vaccine mandate, and it's okay. What the court determined isn't okay is for the federal government to require certain employers to implement a vaccine mandate. And the reason I say that is because at the same time that the Supreme Court said it's not okay for OSHA to mandate employers with more than 100 employees be vaccinated, they did say that it's okay for the government to require healthcare providers to mandate the vaccine with their employees. Very bizarre. And the reason is, this is really interesting, not on the merits of whether it's okay or not to mandate the vaccine. The government has more power in situations where it's paying people. So the reason why healthcare workers are allowed to, why the government is allowed to require healthcare providers to do this is because they receive federal money. They receive payments from Medicare, Medicaid, and the government is able to make greater stipulations on recipients of government funds. So here you have a situation where healthcare employers, if they want to receive Medicare and Medicaid funding, which all do, they have to mandate the vaccine for their workers. But outside of healthcare, it's no-go right now. I would anticipate that the government, I don't know this for sure, I anticipate that the government is going to not pursue the vaccine mandate anymore. So, incidentally, a federal judge ruled that it's not legal to require federal employees to be vaccinated. That just happened within the last couple of days. So we have decisions all over the place. But for right now, if you're an employer in this room or on the call, unless you're in healthcare, if you receive Medicare or Medicaid funding, there's an exception to the rule, but everyone else at this point is not required to mandate vaccines with their employees. On the other hand, if you're an employer and you want to implement a vaccine mandate, you're allowed to do that. It's that the government cannot make you implement the mandate. So it's a lot of twists and turns to this, and it's in the rearview mirror for most of us now. So what about what about OSHA? We have a record-keeping workshop today. We're talking about how to record cases. What do we do with a COVID case? Well, the agency issued guidance that you are required to record a COVID case if it's work-related. Now, how are you going to determine absolutely that it was a work-related case? It's impossible. We can't know the origins of where the COVID came from. There's a common sense element to this, and OSHA knew that this would be an issue. So what they've said is, as an employer, if an employee comes forward and says, I have COVID, then what OSHA wants and expects from you is to do a thorough job investigating to the best of your ability to determine if that case may or may not be work-related. So go through the effort of asking questions. And you may want to do this anyway simply for the purpose of contact tracing. If you have people working in close proximity, you may want to go ask the employee who tested positive, who were you working with, and then go back and explore those potential contacts and do your due diligence. And at the end of the day, it's not going to be possible with 100% certainty to say if the case was work-related. Now, common sense, if you're in healthcare and you're working the COVID floor of a hospital and you contract COVID, then it might be a little bit more reasonable to assume that it was a workplace exposure and record that event. But generally speaking, it's going to be impossible to do that. And one of the things we'll talk about today, and many of you already know, which is part of record keeping, if you have certain incidents, fatalities, obviously, but if you have serious injuries requiring hospitalization or amputations, those are injuries that need to be reported. And COVID is no different. So if you have an employee with a work-related case of COVID that was hospitalized, that's actually a situation, if in fact it's truly work-related, that has to be phoned into OSHA. And we'll talk about those reporting requirements later in the presentation. So, you're going to want to make a good faith effort if somebody comes forward and says that they have COVID. Clearly, if this is a remote work situation where you have an employee who has COVID, that's not going to count because they never were in a workplace. So look at this through the lens with common sense, and we'll get to the right place. So another thing that came up, and I found this was very interesting. Originally, OSHA instructed employers, so this is before the vaccine mandate, some employers were mandating the vaccine. And generally speaking, OSHA has always said that if something happens in the workplace, that it's going to be work-related, and therefore the employer needs to take responsibility by recording that event on the OSHA log. So originally, OSHA told employers that if they were requiring vaccines, COVID vaccines, to be in the workplace, and if an employee suffered an adverse reaction to the vaccine, that would be recorded on the log because they've required the employee to do that. It was not an option. They required the employee to get the vaccine. If they suffered an adverse reaction, well, that was the employer who required it. They should take the responsibility and accountability to record it. Literally, I think it was 3 or 4 days later, OSHA reversed their position on that because what would happen is it would discourage employers from mandating the vaccine. So if an employer mandated the vaccine, somebody got sick from the vaccine, they'd have to take the penalty on the OSHA log. OSHA said, well, that was pretty stupid. So literally 3 or 4 days later, they said, no. If you mandate the vaccine, there's an adverse reaction, including death, you don't have to put it on the log. So this whole thing has been very interesting to watch from 30,000 feet. And you might say, Gary, you're a really strange person if you find things like that interesting. But I've been in safety for 40 plus years, and that's what it does to a person. I used to have hair. All right. So Any questions from our people in the audience live about OSHA and vaccines? Anything? All right. So let's move on to OSHA.
We do have a question from the live chat.
Okay.
Can you comment on company size and how that impacts record keeping and reporting?
That will be covered later in the presentation.
Gary, has there been any other emergency orders like this in the last 30 years that you've seen?
There was one on benzene, and it was actually overturned by the courts. So these emergency temporary standards are a workaround truly meant for emergencies, which one might argue that COVID was an emergency, but very rarely used. And the reason the courts are so skeptical is because they can be used, they can be overused and not used in the way they were intended. I mean, the rulemaking process is there for a reason, and it's to give all stakeholders a chance to give input. None of that was done with these emergency temporary standards. Nobody was consulted. It was just, here's the law, you have to comply.
And one more question from the live chat. Is the current discussion about OSHA/COVID only related to companies with greater than 100 enrolled employees or small groups too?
It includes everyone. So anyone with an employee who is hospitalized as a result of COVID, work-related, must make a report to OSHA. I'm going to get into the details about who needs to keep records. That was another question. But generally speaking, if you're an employer with less than 10 employees, you don't have to keep an OSHA log. If you have more than 10 employees, you have to keep an OSHA log, unless you're in certain industries. For example, CCIG as an insurance broker doesn't have to maintain OSHA logs at all. I'm going to get into these complexities as we get into the OSHA record-keeping standard itself. All right, so let's take a look, generally speaking, at what OSHA looks like in a Biden administration, because each administration is different from another, and they all pick the Secretary of Labor as responsible for OSHA. And each president picks their own cabinet-level position, Secretary of Labor, each who has a different agenda. So we see differences from administration to administration in how the agency actually operates. So needless to say, because Joe Biden was President Obama's vice president, the OSHA administration within the Biden administration looks a lot like it did during the Obama presidency. Biden actually made some statements during his campaign that give us some insights into where the administration is going to go, and understand that COVID has really affected even government agencies. The agency at one time, and maybe even still to some extent now, has been reluctant to send its inspectors into workplaces. So they attempt to do things virtually, which is kind of difficult to do from a health and safety perspective. So a lot of what OSHA may have wanted to do in the last year have been actually kind of stunted by COVID, but they're still out there, and they're investigating complaints. Obviously, they're investigating fatalities and accidents. But nonetheless, some of the hints that President Biden gave during his campaign, one thing was to double the number of OSHA inspectors. So that's significant. Double the number of inspectors means that we will have more inspections in a different environment.
Can you speak to the reason for that and the agenda behind it?
Without getting political? Yeah, the question was, can I speak to the reason why they would double the number of inspectors? And I guess to be politically correct, the administration believes that there aren't enough OSHA inspectors out there to adequately inspect different workplaces. I try. Okay, now this is really interesting to me because I've been in safety for 40 plus years. I think I'll stop at 40 plus, 42 now, so I can stop counting. But I believe in safety, I believe in the reason for it, but there are some things that just go too far. And one of the things that went too far, because I actually had a client in my previous life before I joined CCIG that was a good solid company, committed to safety. Unfortunately, they had a couple of fingertip amputations, and they were inspected by OSHA. Willful penalties, willful violations were issued, a couple of $100,000 worth of penalties. But the worst part of it was that, that there were press releases in the local media that basically shamed this employer. And OSHA's remarks were that they didn't care about the employees' health and safety. I don't know how you could get into the mind of the owner to know that, because we worked with this company and we did help them with safety programs, and they were committed to safety. And in fact, one of the 2 fingertip amputations was entirely the fault of the employee who had his fingertip amputated. So the owner was really discouraged. He was more than discouraged. He was furious because this press release, he was very active in the community in Wisconsin, and really hurt him. OSHA has talked about returning to this policy of shaming employers. So if you're subject to an inspection, and it happens to be a large inspection with a number of citations and penalties probably exceeding $100,000, the scary thing is there may be press releases from the agency. And their thinking is, well, if we shame employers, they'll do the right thing. That the entire philosophy is, if employers are afraid that they're going to be shamed, they will do the right thing. Well, companies do the right thing because they want to do the right thing. And don't get me wrong, in my career, there are employers that don't care. Really don't care about anybody's health and safety. I've seen them. So it is what it is. But this is just these are things you should be aware of. Another thing, we're going to talk about OSHA's electronic record keeping rule, which is a little bit confusing, and I'll talk about this in the presentation later. The record keeping rule, in addition to requiring employers of a certain size to file their OSHA logs electronically, also talked about safety incentive programs, talked about and limits on post-injury drug testing. And that's kind of scary. So in the Trump administration, they told OSHA you cannot enforce those aspects of the standard because, and if you ask me personally, do I agree with safety incentive programs? I do, but they have to be set up in the right way. If you simply reward people for not having an accident, that's not a good kind of incentive program, because sometimes you just get lucky, right? So I think safety incentive programs should reward the behaviors that lead to a good safety record, not the simple fact that you've dodged the bullet just by luck alone. But restrictions on post-injury drug testing, I'm not so sure about that. But so, for example, what OSHA wants to see is, instead of a blanket post-injury drug testing program, what they want to see is a for-cause drug testing program. So, used to be, for many employers, if somebody was hurt or injured badly enough that they needed to go to the clinic, they needed to have a drug test. And that was the basis. If OSHA moves forward with re-implementing this, that would be a violation. And it's a violation, believe it or not, of the employee's right to report an injury. So OSHA says you can't do blanket post-injury drug testing because you're going to discourage employees from reporting an incident. Because they know they're going to test positive, they're not going to report the injury. That's where that comes from. We do expect inspections to increase. In fact, it really, in the first part of the administration, first part of COVID, before COVID got so entrenched into things, we did see an increase in inspections by the agency early in 2020. Needless to say, COVID is a specific disease. The agency realizes that there are other communicable diseases that may be present in the workplace. So the agency is considering promulgating is the legal term, an infectious disease standard that would be all-encompassing. So it would be Ebola, it would be COVID, it would be other communicable diseases. So that's going to take time to do. I wouldn't expect to see anything like that within the next 2 years at the outside, but it's on the radar. It's on their radar. So that's a little bit of background on what we as employers should see from OSHA under this current administration. I'm going to move on to a different subject right now, which is one that many of you should be aware of. And it's tied to record keeping, entirely tied to record keeping, which is going to make what we're talking about today much more important. The injuries that you record on the log, at the end of the day, could determine whether or not your business is targeted for an OSHA inspection. So here's how the program works. This has been in place since 2018, and there's nothing you really need to do about this other than be aware of it. If you are subject to electronic record keeping, which we're also going to talk about, if you're subject to electronic record keeping, you're giving OSHA the data that they need to prepare the list of employers for inspection. And the way it works is employers whose injury experience exceeds the experience of their peers could be targeted for inspection. So another topic that we're going to get to, I keep teasing with all these things we're going to get to, we're going to talk about how important it is for you to identify your business correctly on the 300A form. It'll ask you for the SIC or NAICS code. Many of you will know what I'm talking about. That is the code that OSHA will use as a reference as your peer group. If you don't have the code correct, you could be putting yourself at a disadvantage. If you're in a more dangerous business, but you pick a code that's in a less dangerous industry, you're creating a benchmark that is not real for what you do. And so if that benchmark code, your peer group code, isn't correct, you could be putting yourself at a disadvantage. On the other hand, if the benchmark code is in a much more dangerous industry and you're not in that industry, then you're at an advantage. So it really cuts both ways. So electronic record keeping, if the data that you submit to OSHA exceeds the incident rates of your peers, you could be targeted for inspection. And the reason is, well, you've given us data that supports the fact that you're injuring people at a rate greater than your peer group. And so we need to find out why that's happening. Well, I keep going back to the point of you want to evaluate each injury and incident on its own, and using the rules that we're going to talk about today, make a decision as to whether or not to put that on the log. I have met so many different clients over the years who say, the rules are confusing, they're complicated, I don't take any chances, I put it on the log anyway. No, don't do that. No, take a look. Use the rules that we're going to talk about today. In fact, I am so passionate about this, I would encourage anybody in the workshop today with a specific situation to reach out to me by email and I will help you, because I hate seeing things on the log that don't belong there. So if you have that case where there was an alien abduction and there was some medical treatment given on some, extraterrestrial spaceship, I will answer that question. I've had so many strange questions when it comes to record keeping, it's incredible. So, number one, if your rate exceeds that of your peers, you could be put on a list to be inspected. Number two, if you are subject to electronic record keeping, but you've never submitted your logs electronically, you're on the list to be inspected because you're not holding up your end of the bargain. This one really interested me. If you do a really, really good job in safety and your record is phenomenal, OSHA has even has an element of this program that says that they're going to do random spot checks for employers who report exceptionally good incident rates. So they don't necessarily trust that your low rates are all what they're cracked up to be. So you could be put on a list randomly because you're doing a good job. Isn't that nice? And if you got nothing to hide, I guess welcome them in and say, here's my logs, but seems like kind of punishment to me. So the rate, and we're going to talk about these rates. I keep teasing things that come up later in the program. OSHA focuses primarily on the DART rate. If you're not familiar with that term, DART stands for days away from work, restrictions, or transfer. So you have an event that results in lost work days, that's part of the DART rate, and or an event that results in restrictions. That is part of the DART rate. And I'm going to show how to do these calculations towards the end of the presentation. What happens is this is collected federally. All these reports, even for state plans, Colorado is a federal OSHA plan. I don't know the surrounding states if they're state plans. Where I came from in Chicago, Illinois, Wisconsin was a federal program, but Iowa, Indiana, Minnesota, and Michigan were all state-run programs. I don't need to get into the nitty-gritty on that today, but states are allowed to enforce their own health and safety programs as long as they're as stringent as what OSHA is. But every employer in every state, whether it's a federal program or a state program, are required to submit this information to the federal OSHA. From there, OSHA distributes the data to the area offices, the area OSHA offices, and the area OSHA offices, given guidance from the federal government, prepare a list based upon the electronic information that was provided. So when I was at Horton, previous employer, we had quite a few employers who were subject to site-specific targeting because the incident rates they reported were high. In some cases, they were high. In other cases, unfortunately, they over-reported on the log. They were recording too many injuries. And I can give you some examples that would make some of you laugh that are familiar with record keeping, but people make a lot of mistakes with this. OSHA had a test program like this years earlier, and interestingly, what they did was they actually published the list of employers whose incident rates exceeded the peer group. And I could go online, it was kind of a chore, but I could go online and find that list. And I guess you might call me a little bit of an ambulance chaser, because when we found the list, we contacted those employers and said, I don't know if you're aware of this, but you're on a list potentially to be inspected. And we were able to get our foot in the door and help them out in some cases. Well, this time OSHA said, we're not going to publish the list. And it's not publicly available. So unless you know, and we're going to talk about that, how to calculate your incident rates and compare yourself to the peer group, you have no idea whether you're going to be inspected or not. And that's kind of scary. Nobody wants an inspection. So the agency is conducting inspections under this initiative since 2018, and that happened under the Trump administration, and it will continue. So, any questions from our live audience on site-specific targeting? All right, so let's talk about the record-keeping standard. So, the record-keeping standard, totally separate standard. It's if you're familiar with safety and health regulations, we have the 1910 standards, not the year they were developed. It's part of a code of federal regulations, part 1910. That applies to industry. And then we have the 1926 standards that apply to construction. We have an entirely set of different regulations for shipbuilding, for mining. So given a specialty, each different type of employer has different regulations, which makes sense. The one thing that is constant is the record-keeping standard, because it doesn't matter if you're in mining, if you're in shipbuilding, if you're in construction, if you're in manufacturing, the way we document job, work-related injuries and illnesses is the same. We can't have a different system because then there's no way to compare things. So Part 1904 stands on its own. And the subparts contain the different pieces that we're going to talk about in detail today. So I have a strange sense of humor. So these pictures may not entirely make sense to you. I'm not sure they make sense to me. But if you can't add a little levity to a discussion about OSHA record keeping, life isn't worth living. Anyway, so the purpose of the standard is really pretty easy: to record all work-related injuries and illnesses. And sounds simple enough, right? But we haven't defined work-related. That actually has a definition. And we haven't defined necessarily what an injury or an illness is with respect to having to be recorded on the log. And that's where the rubber meets the road, and we're going to talk about today. Now, I do want to point this out because this was one of the questions that I posed at the beginning of the presentation. OSHA makes it quite clear that in the statement that you see here, all these words, that, and they do it in a clever way. They say here that just because you have a recordable event doesn't mean that an employee is entitled to workers' compensation benefits. But on a more broadly stated level, there is a difference between a work comp claim and an OSHA recordable event. And we'll talk about specific examples of that. We'll delve into that a little bit more later. But so just understand, the simple fact that you have a workers' compensation claim doesn't mean that it goes on the log. Good example of that would be an employee claims a work-related injury. So you submit it to the work comp carrier. Maybe the work comp carrier pays a little bit of medical out. Maybe they even pay a little bit of disability out, which they'll never get back. But through the investigation process of both the employer and the workers' compensation carrier, it's determined that that is not a work-related event. Well, there's been money spent, and there was a work comp claim, but it's not recordable because the investigation determined it wasn't work-related. So you could even have situations where initially something becomes recordable, but then it's taken off the log when an investigation determines that later. So the one most important thing is, please, in your mind, separate workers' comp claim from OSHA recordable. All right, so this gets a little bit confusing because we have all kinds of different trigger levels for different aspects of OSHA record keeping. So keeping a log is what we're talking about in this part of the presentation. An employer with less than 10 employees at any one time during the year isn't required to keep an OSHA log. So you could be in the landscape business where during the winter time you do a little snow plowing, some minor stuff, and you have 8 employees. But during the summertime, when landscape work is more active, you have 12 employees, you're going to have to keep an OSHA log because for 1 month you employed more than 10 people. Also, it's for the total number of employees, not the number at any one location. So an example there, you operate convenience stores. Each convenience store has 8 employees, but you have 10 convenience stores. You have to keep logs because the total employment is more than 10. This is an interesting part that a lot of people aren't aware of, but OSHA has actually identified the businesses that are not required to keep logs. And generally speaking, there's a list of them if you wanted to see it by NAICS code, but specifically employers in low hazard businesses like retail, service, finance, insurance, real estate. It's kind of interesting because retail can be kind of dangerous with forklifts and stocking and material handling. Not subject to keep OSHA logs. That's been in place since the record keeping standard existed 50 years ago, something like that. So the exempt industries are actually found in Appendix A of the record keeping standard. If you're not sure if you need to keep them or not, that's the place to go. If you want to reach out by email, by all means, let me know. I can work through that with you. The interesting thing, here's what happens. People always latch on to that. Oh, okay, so I have less than 10 employees. I don't have to worry about OSHA. Not so fast. The only thing you don't have to worry about is keeping a log. If you use hazardous chemicals, you're still required to do HAZCOM training. If you have forklifts and you have less than 10 employees, you still have to do forklift operator training. So the only exemption is from keeping a log. Everything else applies, including if you had an employee who was hospitalized as a result of an injury. You don't have to keep a log, but you have to pick up the phone and contact OSHA, even if you have less than 10. You know, I don't want people to do more work than they have to, but if you're really concerned about safety, there's an argument to be made to keep the log, because when you keep the log, you can actually do the calculation to see if you're doing good compared to your peer group. I would think most people on the call today are from organizations with more than 10 people. All right, Subpart C deals with the forms and the criteria, and here's where we get into the definitions. Work-relatedness is a work-related activity in a work environment, and all these things are going to have to be further defined, that results in injury or illness. And it also includes, and this is the part that aggravates many of you in the room, it's work-related activity in a work environment that results in the aggravation of a pre-existing condition. So those of you who are participating today are probably aggravated every time they have a workers' comp claim where somebody comes to work for the company. They've had 3 previous back surgeries from injuries they've sustained at work or at another employer, and all it takes is for them to bend over, pick something up, re-injure the back, and you've bought that claim again. And not only have you bought it from a workers' compensation perspective, but you've bought it from an OSHA recordable. So, you know, we have some limitations on what we can do at the front end when it comes to hiring, but you basically take that employee as they are, and if they come with pre-existing conditions, things that happen to them that are work-related are going to be a work comp claim, most likely, and an OSHA recordable. So it is what it is. What is the work environment? Well, in today's environment, it's even different than it was 2 or 3 years ago. We have so many people working remotely, and the home is a work environment. So that becomes an interesting question. An employee claims they were injured at home. What do we do? We're going to get to that section. I keep teasing things. I don't know why I keep doing that. But it has become a different thing. And employers have crews that work out in the field. It's not always in a factory within 4 walls. So the work environment itself is kind of an interesting and different thing. It includes obviously not just physical locations, but equipment and materials that people may use. We'll get into a little bit more common sense about work at home as well. There are exceptions. So the way this works is it will likely be an OSHA recordable unless these exceptions apply. So the first exception is if the employee is injured, if they were present and injured as a part of the general public. So I had to return something that I borrowed from a coworker. So I drive to CCIG's building to return that tool that I had borrowed from a coworker. I'm not here, it's my day off, I come to the building, I return the tool. On the way up the stairs, I trip and fall, and I injure myself. Well, I'm not at work. So if I'm there as a member of the general public, not recordable. Voluntary participation in company activities. This is actually, there's some case law with this. So if we're at a picnic and there's a pickup softball game and somebody is injured sliding into second base, if it's a voluntary activity, it's not OSHA recordable. But there's actually, you know, people have interesting jobs. Anyway, some examples, real life examples of things that have happened is that larger companies, very competitive within the company. And in a pickup softball game, There were people, a true case example, where the company or a leader within the company said, Bill, you're the best hitter we got. I know you got something going on this weekend, but you have to play softball. You have to be on our team because we want to win. So the mandate was given that certain employees had to participate in the softball game. If it was a required activity and the employee was injured, it's OSHA recordable. How would that play out, Natalie, with a work comp claim?
Yeah, and I've seen cases where it would be covered. They take a lot of things into consideration, whether they're on the clock, getting paid, paid for their transportation to and from the event. So it's kind of a gray area.
So for those of you virtually, the example, it could be a work comp claim, depending on circumstances. Pay, transportation arrangements. So anyway, you have to be careful. When you require people to do anything is when you start getting yourself into trouble. It's good to know that OSHA won't hold you responsible for any injuries that an employee suffers while eating, drinking, or cooking. Now, the one exception to that is if your job is a cook and you're injured cooking, then that obviously would. But if you're an employee, we have a kitchen here at CCIG. If I was injured preparing my own lunch, that is not an OSHA recordable.
What if you're injured preparing for others, like for company picnic or something like that, while everybody's working?
Yeah, I would say if you were cooking on a grill at a company function, you weren't being paid, it wasn't your normal job, I would tell you I wouldn't put that on the log.
But you were being paid, say you were on shift that day and they're like, hey, you need to go run this as a manager or administrator or something like that. You need to make hamburgers for these people.
Got it.
You see what I'm saying?
So the question was for those of you virtually, if it was a company picnic and you were being paid and somebody said you need to cook burgers for everybody and they were hurt, I would say that's an OSHA recordable event.
I had one, Gary, where somebody made fruit water for the department, and she cut her finger on a pineapple, and that was considered work-related because that was kind of her job to make the water.
Interesting.
2 pineapple cuts. Dangerous fruit.
Be careful with pineapple. So yeah, I mean, all these things, it's a gray area. And where there's a gray area, using the rules that we talked about, make your decision. And your decision should always lean towards what do I need to do to not have to put this on the log. Another exception to work environment is performing personal tasks at work. Lord only knows what they might be talking about. I know I'll never be injured combing my hair. I'm so committed to safety. This is by design. I really can't be injured grooming. So that's how committed I am to the profession. Injured while grooming or taking medication and self-inflicted injuries. Used to be, back in the old days, maybe I shouldn't tell these old stories, but back in the old days, it wasn't work comp has been around work comp's been around longer than OSHA has, many, many years. And it was not unusual, especially in Chicago. My father was a machinist, and he knew guys that would intentionally amputate digits to get money because you go to the table, right? And this is worth X amount of weeks. And if somebody needed a little cash, they'd sacrifice their part of their finger. Most work comp laws don't allow you to collect if you can prove that it was intentionally done. But my dad would know people that actually did that for a little bit of extra cash. This is where it gets interesting because we always have a lot of questions. What about automobile accidents? What about parking lot incidents? And parking lot incidents, I'm sure, become an issue when it comes to workers' comp, especially on slippery days like today, slip, trip, and fall. So what OSHA says is that injuries that are sustained in auto accidents on company property when commuting, that phrase is very important. So I'm pulling into the parking lot here as someone is pulling out of the parking lot. If we collide any injuries that I sustain coming into work in the car are not work-related, not recordable. However, if I'm walking my car, because now I'm no longer commuting, I'm out of the car, my commute is finished, and somebody pulls in and hits me as a pedestrian, my injuries would be recordable. So in the car, 2 collisions, commuting, no problem. Once you're a pedestrian, either going from the building to your car, from your car to the building, those injuries would be recordable. Good to know that illness from the common cold or flu at work is not recordable, which is interesting because COVID might be. But we have an exemption for the common cold or flu. And the reason is because can you imagine how many incidents would be on the log? And with Omicron, I mean, you know, fortunately they've given us that opportunity to say, you know, they will only find you at fault if it was obvious. There's no way to tell. There is no way to tell. So I found it interesting that COVID became such a big issue as far as record keeping when the agency exempts the very common flus and colds in the workplace. But it is what it is. This is a big paragraph, and I violated PowerPoint 101, which is never put too many words on a slide, but I did it for a reason. And ultimately, all this verbiage basically says the employer determines what goes on the log or not. It's not me. It's not OSHA. You can call them for advice. They don't trace your phone. Oh, we got to go get that. They don't have caller ID and go chase you down. You can call them. Quite a few OSHA people, very reasonable, good to work with. Problem is, there's a handful of people that don't operate that way, and you have to protect yourself from the ones that may tend to go overboard. But the bottom line is, you determine what goes in the log. I would tell you, if you make a decision to record or not record something, you support yourself by having documentation backing that up. Many employers don't do that. But if you had a situation that you suspected was not work-related, and you had good, solid documentation, that's all you're going to need. That's all you're going to need. You may get a record-keeping audit, probably not likely, but if you do, if you have that documentation supporting your decision, OSHA tells you you're the one who makes the call. So based on the things that we're talking about today, if you make the call and you document the reasons why you made that call, you're going to be fine. They get into a little detail about travel-related injuries. And I have an interesting story. In today's politically correct world, I'm not sure if I'm on the edge, but I've told it for years, so I'll tell it again today. Injuries sustained from non-work-related activities at a hotel are not recordable. So I'm out of town on business, and I'm at the hotel. If I slip and fall within the hotel while I'm out of town on company business, it's not recordable. So, situation, a friend of mine who worked for another company told me a story, and the story involved a sales rep who was out of town on business, and the sales rep had attended some kind of convention, and I don't even remember what the product or service was that was being sold, but ended up meeting a potential client, and the two of them got along famously and ended up back in the hotel room. So this is where it starts getting a little bit on the edge. So anyway, as the story goes, there was an injury sustained in the shower with the prospective client. And the friend of mine who worked for this company, it was a fairly large company, and you know, there were attorneys involved. So this workers' comp and potential OSHA case became quite the conversation around the company water cooler, if you will. So at the end of the day, and part of the humor involved was apparently the sales rep made the sale. So the end of the story was, could that have been a work-related event because the sale was actually made from activities that were engaged in the shower at that hotel? It just made for a funny story to tell. Anyway, so there you have it. Injuries sustained in motor vehicle accidents while commuting from your motel to where you're going to go, not recordable. It may be a different situation when it comes to comp, but OSHA and work comp are two different things. So I get in my car from the hotel, I drive to where I'm going to provide the service, and any accident I'm involved in, no different than if you get in your car and you go to work. You commute here in the morning and you get in an accident, sorry it happened, it's not work related. Doesn't go on the log, shouldn't be a work comp claim. You know, and they even get into detail, nitty-gritty detail. Injuries sustained as a result of a personal detour, this is a lot of words, from a reasonably direct route of travel are not recordable. So, I'm going from here to my home in Windsor. We just moved into a home in Windsor. And there is a Chicago pizzeria on my way home. And it's not off of 25. In fact, I have to drive 15 miles out of my way to get the pizza that I want to eat. So if I'm going from point A to point B, not home, that was a bad example. I'm going from point A to point B, not my home, it's during the workday, and I go out of my way to get a slice of Chicago pizza 15 miles out of the way. If I'm involved in a motor vehicle accident or an injury getting that food, that's beyond a reasonable detour, it's not going to be recordable. However, if I am going from point A to point B at work and there's a 7-Eleven and I need a bottle of water and I'm thirsty, if I get out of my vehicle to get that bottle of water, that is OSHA recordable if I slip, trip, and fall. So that's where that comes into play. So they don't define what a reasonably direct route or detour are. Common sense. Work-related injuries in the home. And this is where OSHA had to be very careful. And this actually started decades ago when more and more people began working remotely from their homes. So OSHA had to draw the line because what are they going to do? Send OSHA inspectors to your employees' homes? And if they find violations, give you the citations? Can you imagine a world where that happens? Now you're going to have to be inspecting. Your job and safety just got a lot more interesting because now you're going to have to go to your employee's home and say, wow, there's a slip, trip, and fall hazard. So what they did was they said that injuries that result from hazards associated with the home itself or housekeeping are not work-related. So if your employee is working remotely and left a dog toy on the stairs and tripped on the stairs and fell down the stairs, not recordable because that was a housekeeping issue. However, injuries resulting from work-related activities at home, moving boxes, something else. Most people that are working from home right now are utilizing technology, computers. So this gets really interesting. What kind of injury could occur from computer terminal work? Carpal tunnel, repetitive motion type injuries. So now we're getting into a little bit kind of a tricky area because if an employee says that I've developed carpal tunnel from doing keyboarding work at home, it could be work related and it very well could be a workers' compensation claim. So that kind of changes the ball game. If to some extent, and I'm speaking, you know, in a preventive way, in some respect, we have to take into consideration how our employees are doing that keyboarding work when they're working at home. Maybe providing guidance and suggestion on how they can set their office up to be more ergonomically friendly. So I would expect, especially with the amount of remote work and COVID, that this could be a growing area and things that some of us as employers need to address. You know, if part of your job at home is to move file boxes and filter through the file boxes. If you pick that box up and injure yourself, chances are that would be an OSHA recordable event. All right. For the benefit of those that are staring at the computer screen and those of you who are here with us, why don't we take 5 minutes? We'll be back at 10:10. All right, we'll get started back again. We have a question from one of the virtual participants about the Pinnacle insurance website that can help you track your logs. To my knowledge, it's not being filed electronically. That's something that you will have to set up an account to do. But with respect to the Pinnacle website, it's all going to depend on the accuracy of the information that you input. I'm fairly new to CCIG. I've met a couple of the people at Pinnacle, but I don't know specifically how that system operates. But I do know that anytime you put bad information in, you're not going to get good information out. So if you have to do any of the entry in that system for any of these injuries, we need to talk about that. If I can't imagine where the Pinnacle website for OSHA record keeping wouldn't have you make some kind of input. Personally, I would be concerned if Pinnacle were producing my logs without any input from myself. I would not want that. I would personally want to have a review of the data that's in there, quite honestly, because there are serious implications to inaccurate data. So from our live audience, and we'll get to the questions from the rest of the virtual participants at the end of the workshop today, from our live audience, any questions before we move forward? Nothing? All right, so let's talk about what a recordable event is. And this is the laundry list of recordable events. An occupational or work-related death. Horrible thing to have happen. Unfortunately, in the course of my career, many dozens of fatalities that I've been involved in, and just a horrible, horrible thing. Never want to be on the back end of that. About, I think we're 4,400 Americans a year killed on the job. Used to be much higher when I started in my career. Back in 1932, there were quite a few more fatalities in the workplace. We've done well, and every year that number does come down. But if you're in any way related to one of the 4,400, it's something you'll never forget. So death is a workplace recordable event. Obviously, if it's work-related. Events resulting in lost workdays. And nothing makes me angrier than to look at an OSHA log and see the name of an individual, the check mark in the lost workday column, and one lost workday. So they were hurt badly enough that they had to miss just one day of work. And then the next day, they came back to work on full duty. Does that sound weird? I see it all the time. And there's reasons for that. We're going to talk about some of those reasons. But one of the more important things that employers should do is to establish a good working relationship with an occupational clinic or occupational physician. So how is it possible that somebody was hurt badly enough that they had to miss one day of work, and then the very next day they were able to return on full duty? I mean, maybe there's a situation where that might make sense, but to me, it screams we had an opportunity at a minimum to bring that person back to work on light duty restrictions. Because the lost workday events, obviously death is at the top of the food chain when it comes to bad events, but a lost workday event in the eyes of OSHA means you guys are doing something that could be done better. And it's just sticks out like a sore thumb when I look at that OSHA log and I see somebody's name and there was one lost workday and then no restrictions. It's like something didn't happen the way it should have with that incident. But lost workdays, obviously recordable event. Events that result in restriction or job transfer. Events that result in medical treatment. We're going to get into more detail about these things. Again, I'm teasing it. Loss of consciousness. So if the loss of consciousness is work-related, then it's a recordable event, even if there was no further medical treatment given. So, for example, kind of scary, if I went into a confined space and I lost consciousness, but somehow I had a harness attached with a retrieval line, somebody was able to pull me out of that space, and obviously I would hope somebody would take me to a doctor, and the doctor evaluated me and said, you're a very fortunate individual to have come out of the confined space alive, because most of the time people don't. But I was rescued, brought back, I regained consciousness. The doctor looked at me and said, you know what, you're a lucky person, go back to work, you're fine, no restrictions. The fact that I lost consciousness is a work-related event and recordable. And then the last one, which is kind of strange, is significant injury or illness that's diagnosed by a physician or licensed healthcare professional. Well, what could that possibly be? If I had an injury or illness, wouldn't I have restrictions? Wouldn't I lose time? Well, it kind of depends on the illness. And the one illness that I'm thinking of that I've seen on the log quite a few is hearing loss. So if I have hearing loss, I'm diagnosed with occupational hearing loss. That is an OSHA recordable event, but I'm not going to lose time and I'm not going to have restrictions. So there are illnesses that may or may not result in restrictions or lost work days that do go on the log. Hearing loss is the most notable of them all. This is also interesting and very, very important, that it's a physician who determines the number of lost or restricted work days. And I'll give you an example of how that works. So I'm injured on the job, and I go to the clinic, and the clinic says, you're going to need 3 days of restricted work activity, reevaluate, and then we may send you back to work. And I'm old school, and I say, you know, damn these restrictions. I really don't feel that bad. I'm going to go back to work full duty. Now, number one, as an employer, you shouldn't allow that to happen. You shouldn't allow an employee to come back on full duty if the restrictions they've been given are in place. So I've had employers ask me this question. So my employee was given restrictions, but they came back to work and they worked with no problem, so I don't have to record this, right? Well, no. It's what's on the release. And if you were subject to a record-keeping audit, they would look in the files for the medical treatment information as well as the release forms. So if you're playing games with that, it could get you into a little bit of trouble. The other scenario, the reverse. Your employee was evaluated by a physician and determined that they could go back to work on full duty, but they don't. They call off the next day and say, I can't come to work because my injury's such that I don't feel I'm able to work. Same rule applies. You go by what's on the paper. If the employee was released full duty, you don't have to take the penalty on the log just because they didn't show up. So you go by the paperwork. And one of the things that I've seen many employers make a mistake with is they don't get those release forms. There's a disconnect between who might be responsible for record keeping and the operations or HR within the company. They're not communicating that information to the person that keeps the log. Extremely important. And those questions come up quite often. Another thing that needs to be taken into consideration. So we have an operation where the employee reports to work at 7 o'clock in the morning. At 7:15, they're injured. And so they're taken to the clinic, and it's a bad day at the clinic. You know it's going to be a 2, 3, 4 hour ordeal to begin with. But in this particular case, they're taken to the clinic. They have to wait in the clinic for hours. By the end of the time that they've been seen by the doctor, it's the end of the work shift and they go home. I actually looked at a contractor's log once. He was rejected from doing work for a general contractor. It was an electrical contractor. And he said, I was rejected because of the information on the log. So I said, Kevin, can I take a look at your log? So he emailed it to me. I'm looking at it, and he's got a check mark in lost work days. And then in the column that has the number of lost work days, he had 1/2. and he had 7 of these 1/2 in there. I said, Kevin, what is this? He goes, well, Gare, you know, when you send a guy to a clinic, it's going to take half of the day, so he's missed half a day. I just put a half lost work day. Well, his rate was through the roof, and he was rejected by the general contractor. They didn't care about the half day that was marked there. You only include the next day following the injury. If I get hurt today and I don't show up to work tomorrow, that's a lost work day. If I get hurt today at 7 o'clock and I don't come back the rest of the day, nope, doesn't count. Something else that was changed probably about 10, 15 years ago now is that we cap the total number of days. So on January 1st, you have an employee who slips and falls, is badly injured, and they're off work for the entire year, 365 days. And by the way, we count calendar days. We didn't used to. But we didn't. The reason we no longer do that is because of people that were creative record keepers like me in the old days. It was amazing how when somebody was hurt and missed time from work that they were mysteriously not scheduled to work for the next 3 weeks. Or vacation time and stuff like that. People played games. So 10, 15 years ago, OSHA said, we're going to stop the game playing. So we're going to record calendar days. Calendar days. So it doesn't matter if it's a weekend. It's calendar days until they've been released to return to work. But because they're doing calendar days, we had to cap the total number. Otherwise, it would look like many more people were getting hurt to a greater extent. So they capped the days. Now, this is really important because let's say it's a Friday and the employee is hurt Friday morning, and the physician, and this is where it helps to have a good relationship with an occupational clinic, they don't know OSHA record keeping, they know medicine, thankfully. But the clinic says to the employee, when are you scheduled to work next? I'm scheduled to work on Monday. So the physician writes the release, may return to work Monday, full duty. You know what just happened? You just bought a 2-day lost workday event that goes on your log because the physician didn't know the record keeping rules. So if you're in a position of responsibility at a company, you have to be aware of that. If it were me, I'd call the clinic back and say, was this employee capable of working the next day? Well, yes, but they told me the next day they work is Monday. Would you please rewrite the release to reflect that they were able to return to work tomorrow? That's huge. And so many people are dialed in to the extent that they're looking at the release form, but they're looking at the release form literally, and that will automatically get you a lost workday event that didn't need to happen. So that's huge. By the way, when we talk about the total number of lost workday on the OSHA log, it's a combination of days lost and days restricted. So not 180 restricted plus 180 lost, it's total combined. So regardless of where those days are piling up, the total number between lost workdays and restricted workdays is 180.
Does that include, so if they're only restricted, they never missed any days, you can also cap that at 180?
Yes.
Not just the lost days, also the restrictions?
Yes, but the combination of both. So let's say I had 100 lost workdays and then I had 100 restricted workdays. I would only record 80 restricted workdays because it's the 100 plus the 80. As I mentioned before, scheduled workdays, no, it's all calendar. So one of the biggest mistakes, and we'll have an opportunity to look at this on one of the upcoming slides, is too many X marks. And if you do this on the Excel spreadsheet, it doesn't care. It'll take your check mark wherever you put it. There are 4 columns where we are to record an event. Key columns. The first column is death. Hope nobody ever has to put a check mark in that column. The next column is days away from work. The third column is restrictions, transfer, restrictions or transfer. And the fourth column is other recordable. We're going to define all of these. But when we have an incident that results in both lost work days and restricted work days, we only put one check mark in, and we put it in the column with the most significant outcome, which was lost work days. So many times I have reviewed a client's log, and where an injury involved lost work days and restrictions, which many do involve, they've put a check mark in lost workday column and a check mark in the restricted workday column. And when you carry those numbers over, you've penalized yourself by double counting one injury. And the Excel spreadsheet doesn't care where you put the check mark in. So only check one. So if you have a lost workday case that involved restrictions, one check mark, lost workday column only. Another interesting area where there's opportunity is injuries that involve restrictions in work or transferring somebody to a different job with less demands. The restrictions are things that keep the employee from performing the routine part of their job. This kind of goes back to the conversation we had about developing a relationship with a good occupational clinic. I would encourage all of you to sit down with your occupational clinic and you're their customer. You're essentially paying the bills through the carrier. You're the customer. And defining what it is that you want to see. And they need to become familiar with your operation. I've always felt strongly that a good occupational clinic should, if you're in a manufacturing operation, should go to your place of business and take a look at what people do. They need to have an understanding of what people do. And the decisions they make and the restrictions they impose have an impact on your OSHA record keeping. And again, these are medical people that may or may not be familiar with the record keeping standard. But here's what can happen with restrictions. You send someone to the clinic. Let's say that the job is a quality control inspector in a manufacturing operation where they use small hand tools for measuring, for inspecting. They're not doing heavy physical labor. Well, for whatever reason, they suffer a strain or sprain injury on the job. They go to the clinic, and the clinic says, may return to work, but no lifting over 50 pounds. Okay, well, right now, we've got a situation where, looking at the release form, that's restricted workday case, right? But what question would you have? Anybody think of a question? Is lifting 50 pounds part of that person's routine job duty? And if a quality control inspector only lifts 5-pound tools and never has to move anything, what they've done is they've imposed a restriction that doesn't apply to the job. Now, what I'm suggesting to you as the employer is that you can, remember that one slide, employer makes the decision? You can say, no, that's not this person's job. You can mark it not as a restricted work activity case. Maybe it involved medical treatment, which is another area we're going to get into here shortly. But don't take the penalty for that. Ideally, what you would do is call the clinic and say, this person doesn't have to lift 50 pounds ever in their job. Would you please give them a clean release, full duty release? So this one's huge. And the less your clinic understands what jobs are being done, the more opportunity there is for this kind of stuff to happen. So the restrictions that are imposed in order for it to be recordable have to relate to the job that's actually done. So this is an opportunity to work with that clinic to get things tightened up where they're actually reflecting the work that is being done by people that they're evaluating and treating. So again, Restriction doesn't include the current work day. It's the next day following the date of the injury. Medical treatment. So the fourth column is other recordable case. This is where it gets a little bit interesting and where we have a lot of questions. So medical treatment is specifically defined by OSHA. We're going to get into it. Doesn't matter if it's a doctor, physician, I don't know, maybe you want to save a buck or two on OC healthcare and use a veterinarian. Some of you might say it's appropriate for our workforce to use a veterinarian anyway. But it doesn't matter who the person is that's providing the treatment. It doesn't affect the recordability. If it's a professional healthcare provider, it could be a nurse, it could be a nurse practitioner, physician assistant, or physician. Doesn't matter. So, medical treatment is not, and I've got a ridiculous example to share, a visit to a physician or licensed healthcare professional solely for observation or counseling. Diagnostic procedures, x-rays, MRI, CT scan, solely for diagnostic purposes. And first aid, which we're going to get into in a minute. So here's my ridiculous example. I slip and fall at work, and I hit my head on the concrete. Now, if I lose consciousness, does that go on the log? Right? Remember that conversation? That recordable event, I lose consciousness. But I don't lose consciousness. Slip and fall, hit my head on the concrete. Somebody calls an ambulance, takes me by ambulance to the hospital. I get an x-ray. I get an MRI. Maybe they throw in a CT scan. I don't know enough about medicine to know if these things are appropriate. I'm sure Natalie would. And you know, some of the scans, they actually inject medicine in order to do that diagnostic test. So here I am in the hospital having all these diagnostic exams, and at the end of the day, could be easily $10,000 work comp bill because this is work related, was witnessed. At the end of the day at the hospital, the doctor says, you know what, you're one tough cookie. You got a headache, but take your ibuprofen that you've got at home and you go to work the next day. It's not recordable. None of that was recordable. I was relieved. Now, how likely is that? I don't know. It's a possibility. Anything's possible. The point is that just because I go to the hospital, just because I have diagnostic procedures, that alone does not determine whether or not that event goes on the log. So we need to take a deep dive. And again, because of my passion about this subject, email me. I'd be happy to answer any questions you might have. First aid. So, first aid treatment. If you take somebody to the clinic and they receive this list of 13 items, which is considered first aid treatment, it is not OSHA recordable. First on the list, using non-prescription medication at non-prescription strength. Well, in the old days, and I used to work for large corporations, Texas Instruments, U.S. Steel, their chemical division, and these were big organizations that really were conscientious about their OSHA logs to a point that they kind of played games with the record keeping. So in the old days, what we used to do was send an employee to the clinic that we had relationships with, and if there was a decision to issue a prescription to avoid the OSHA recordable, we just tell the doctor, well, can't you just tell the employee to take ibuprofen, but take it at prescription strength? So instead of taking 400 milligrams, I can't remember, take 4 ibuprofen at 800 milligrams, and it wasn't a prescription. So we could avoid the OSHA recordable. Well, OSHA caught up with that. And so they've said if you're using over-the-counter medication, but a prescription strength dose, you're going to have to take that as a recordable. But generally speaking, Natalie, that's a question maybe for you. Do you see a lot of prescriptions with work comp claims?
Yes, it's pretty annoying too.
And it's follow the money, right? Again, this goes back to a relationship with the clinic. You know, obviously we want to give our employees the best medical treatment we can, but we want to do so in a manner that doesn't hurt the company. And hurting the company is overusing prescription medication that cause that event to be recordable. And you don't like to play doctor, but it's something that we want to communicate to the clinic. We want you to practice good medicine, but if there is an event where the employee could take over-the-counter medication, we'll buy the bottle of ibuprofen for them. We just don't want you over-prescribing. So part of the process of developing that relationship. Tetanus shot, I cut my finger, not badly enough to require sutures. They can put a butterfly bandage on it. They can tape it. They can put duct tape on until I don't have any more duct tape. That doesn't make it recordable. Neither does the tetanus shot. Is there anybody who ever remembers their last tetanus shot? I probably had more than I need. When was your last tetanus shot? Hell, I don't know. Just give me another one. Nobody remembers. I don't carry a card with me. Oh, okay. December 2nd, 1972. All right. Simply cleaning, flushing, soaking wounds, all that kind of stuff is first aid treatment. Stuff that you could actually do if you were properly trained how to do it. Bandages, Band-Aids, gauze pads, none of that that's used to cover a wound are recordable. Sutures, absolutely. Hot or cold therapy, it's first aid treatment, doesn't matter. Non-rigid means of support, an elastic wrap around an ankle, an elbow, a wrist. If it's non-rigid support, not recordable. Obviously, to transport a victim by ambulance using immobilizing devices, that doesn't make it recordable. I always found this one interesting. I'm sure many of us today have smashed your finger with a hammer and you get a blood blister that develops, right? And sometimes, medically speaking, the best thing you can do for it, which is kind of a horrible thought, is to drill through the nail to relieve the pressure. To me, that's kind of a medical procedure because I'm not going to pull out my battery-operated DeWalt and put an 1/8-inch drill bit on it and drill through my nail. I just don't get into that. But at a clinic or a hospital, if they drill a fingernail or toenail to relieve pressure, that procedure is not considered to be a recordable event. Actually, one of the things I do to emphasize the importance of eye protection is there's a number of treatments for removing debris from the eye, which is on the first aid list, by the way. You can flush the debris out of the eye at a clinic by a doctor, and that's first aid treatment. You can swab a particle out of the eye, and that's first aid treatment. When you have embedded objects in the eye, things get a little bit more difficult. And one of the reasons why I talk about the procedures in a group of people is to encourage them to wear, say, eye protection so that they don't have to go through these things. But if you have embedded objects in the eye, honestly, the way they get that out is essentially with like a dental pick, where they hold your eye open and they go into the eye and they actually pick the metal out of your eye with a stainless steel instrument. Sounds pleasant, doesn't it?
My husband had that done. He got something in his eye. They used a needle and got it out, and then he had a rust ring, so they had to scrub his eye to get the rust ring out.
So for those of you virtually, one of our participants, their husband got metal in the eye. It was taken out with a needle in the eye, and then because it oxidized and rusted, they had to scrub the eye. So I would encourage everybody to wear eye protection. The most severe treatment for embedded objects, especially when there's oxidation, is, believe it or not, to drill it out of the eye. So you take a little dental drill and, please be still, sir, hold your eye open. So it's just a lot easier not to get things in your eye if you can help it. I'll never forget, I was doing a OSHA 10-hour for a carpenter contractor and talked about eye protection. And one of the foremen in the room, who had a glass eye, you could tell when these people came in for training, you could tell, and talked about eye protection, and he stood up, pretty powerful statement, and He said, you guys, he goes, you know I've got the glass eye. He goes, a lot of you know how I had this happen, but some of you don't. He said, when I was young, I was framing, I was hitting 16 penny nails with a hammer, no eye protection. The nail came back, went through my eye. He goes, my first reaction was to get that nail out of my eye. So he pulled the nail, and he went on to explain that when he pulled the nail out, it dislocated his eye. So he was looking at his eye while it was on the nail, and he's holding it, asking for help. And he said, yeah, he goes, I'll never forget that. He goes, anybody who's worked with me ever since that happened has never seen me without a pair of safety glasses on. I'm thinking, well, no lie, dude, you're down to one eyeball. It's a hell of a time to get religion. He lost one of his two eyes. He ain't gonna lose that second eye. But he kind of wishes that he would have made a different decision back when that happened.
Gary, we got a specific question related to this topic. And this is from Jeffrey Greer. Repeat it for us if you can. An enrolled employee gets something in their eye, sent to clinic flushes the eye, no meds, no lost time. Is that reportable?
Based on this description, I'll repeat it. The employee got an object in the eye, went to the clinic, had the object removed through flushing, swabbing, no invasive procedure, no medication. That's a great question too, because oftentimes what'll happen is they'll issue a prescription for salve that goes in the eye. That would make it recordable. If they didn't give the salve prescription, then it's not recordable. All right, so we beat that next point on the slide to death about the eye, removing splinters or foreign material from areas other than the eye with tweezers or whatever, not recordable. So we need to look at this list. If it falls anywhere within this list, not recordable. Finger guards, massages, drinking fluids for relief of heat stress, that's all first aid treatment. That's the all-inclusive list. If it falls outside of one of those 13 things, then it's going to be OSHA recordable, other recordable. And remember, only one check mark in one of those 4 columns. So obviously, we can have a person who loses time, it has restrictions, and was given medication. You never want to put 3 check marks in the columns. 1 column, lost workday column only. Loss of consciousness, I talked about this before. If it's work-related, it must be recordable. We had a client who had a pipe fitter that lost consciousness on the job. Safety director was concerned about it, reached out to me, said, I'm not sure what to do with this. I said, well, do you have a diagnosis yet? He says, no, it just happened. I said, well, why don't we wait to see what comes back from the doctor? Well, it turns out that the employee, there was nothing unusual in the environment. It wasn't super hot, wasn't super cold, wasn't a confined space where lack of oxygen would be a concern. What turned out happening is the employee suffered from extremely low blood pressure. And with extremely low blood pressure, you can be prone to periods of blacking out, losing consciousness. So it was a personal issue. There was nothing remember the aggravation of a pre-existing condition? There was nothing in the workplace that would have aggravated his condition, which happened to be low blood pressure. Needle sticks and sharps, typically encountered in healthcare, is a recordable event, irrespective of whether or not that needle could have potentially carried disease. And I found this kind of unusual, mainly because I've been doing this so long, I try to find what's odd about things. But if you have an employee in healthcare who suffers a needle stick, that is to be recorded on the OSHA log. It's a recordable event. However, if you're in healthcare and you're splashed with another person's blood or body fluid, and that happens in healthcare, it's only recordable if you are diagnosed with a disease. So here you have a needle stick. They don't even care whether or not it might carry infectious disease. You have to record it if you get a needle stick. But if you're splashed with another human's blood, you only have to record it if you contract the disease. Just seems strange to me. Why is one thing handled one way and another the other? It is what it is. So when it comes to hearing loss, the only way you're probably going to be able to record hearing loss is if you're doing audiometric testing. So that's kind of a weird situation. You could have a workplace where hearing protection should be provided and a hearing conservation program should be developed, but if you're not doing any of those things, you won't have the data to determine if somebody has a hearing loss. And in the Chicago environment, it was interesting, especially in construction, because the OSHA standards are different from a hearing protection standpoint in construction than they are from industry. But one of the things, especially with heavy equipment operators, is when they were getting ready to retire is when they'd file a hearing loss claim. We called it a retirement enhancement program. So at the end of their long career operating heavy equipment and machinery, they'd file hearing loss. So the way those rules work is hearing loss must be diagnosed by a physician or licensed healthcare professional, and it deals with a standard threshold shift. Now, some people engage in activities. If you went to a rock concert on Sunday and then had your audiogram on Monday, you're going to show evidence of hearing loss because you have temporary hearing loss from the loud activity you were involved in. So OSHA does allow retests in a quiet environment. Sometimes it's hard to control what the employee is going to be doing, but if you retest within 30 days of the previous test, you may see a different result on the audiogram. So before you take the hit for the recordable hearing loss event, and I don't know how many clients we have that have hearing conservation programs, but this would apply primarily to those clients. All right, so as far as the OSHA forms are concerned, we have the 300 log. We're going to take a look at these. We have the 300A summary form, and then we have what's called the OSHA 301 or equivalent. And I apologize, this is an old presentation I used from my previous employer. I don't know what the Colorado First Report of Injury form number is. Is there a number to it? I'll take your word for it, Natalie. WC64. In Illinois, we called it the Form 45. But anyway, the point is that OSHA requires that you maintain the 300 log for those employers that are subject to record keeping, 300A summary form, and then it's called the 301 or the equivalent, and they take the state first report of injury forms as the equivalent. Is anybody here filling out the 301? Some employers do that. Are you? It's actually a better form. I don't know about the Colorado form. Certainly better than the Illinois form, because the Illinois form was terrible. So you're doubly good. You're protected. All right, so this is just a screenshot of the 300 form. Pretty easy. Case number, no method to the madness in the case number. You may have your own numbering system. Most people just have number 1, number 2, 3, 4, 5, and so on. You can name them so that you'd be able to identify departments or divisions. You can come up with your own numbering scheme. Doesn't make a difference. Employee's name, job title, pretty simple. Date of injury or onset of illness, obviously pretty straightforward. Where the event occurred, they kind of want to know a general location. Column F is where you can get into a little bit of trouble, and we're going to talk more about that. This is the rest of the form, and these are the columns. Virtually, I don't know if you can see this, but the 4 columns at the left of the slide that you're looking at: death, days away from work, remained at work, either job transfer restriction or other recordable case. The point here is for every entry on the log, there should only be one check mark in one of these 4 columns. If you see days away from work and job transfer restriction, you just double penalized yourself. You're counting that incident twice. Here is where we actually enter the actual number of days away from work and the actual number of days on restriction. The total of these two columns, or any one column, should never be more than 180. And then here is where we actually record the event. By the way, respiratory condition, if you had a work-related COVID case, is where that would be recorded. Respiratory illness. The 300A form, and this is where I think OSHA's really done a disservice. You just put raw numbers in here. You put the raw numbers in here. They don't require you to do an incident rate calculation, which we're going to talk about at the end of the workshop today. But that's where the value is. The value of doing these numbers is making the calculation and comparing it to your peer group. Everybody knows where a work comp mod is, right? And the work comp mod is based essentially upon the type of work you do. So if you look at an experience modification rating, your rating, and compare it to another company that does the same thing, it's an apples and apples comparison. Here is the same thing, but they don't have you go to the effort of making the calculation, which we'll talk about. So if you use the Excel spreadsheet, it carries these numbers over for you automatically. Or you can do it by hand. This is the right side of the 300A form. One of the things I pointed out before that's extremely important is to get your code correct. Total number of hours worked. I'm making points that we're gonna cover here in a minute. Another area where a lot of employers make a mistake with the total number of hours worked. Typical scenario for most companies that I've worked with is the person responsible for the OSHA logs will go to payroll and say, I need you to run a report telling me how many total hours were worked for 2021. So what's interesting about that is, so payroll runs the total number of hours, which is going to include overtime hours, but many times when you go to payroll and tell them to ask them how many hours were worked, who is left out of that count? Anybody? Ooh, good point. We're going to talk about temps. Temp hours, if they're directly supervised by you, need to be included. Not subs. Salaried employees. When you go to payroll, they're going to run a report and they're going to tell you how many hours were worked typically by people that are hourly. But you have salaried people. You have people on the floor, supervisors, that are salaried. And they're paid not on an hourly basis, they're paid on salary. So what you do with salaried employees is go to payroll, ask them how many hours were worked, make sure it doesn't include salaried, but then what you're going to want to do is, OSHA allows you to do this, 2,000 hours for every one salaried employee. That's how many hours people work a year, 2,000 hours, ballpark. It's a good round number. So if you're going to payroll and it's not including your salaried workers, you're leaving out those hours. Hours are a good thing when it comes to doing your calculation. It's part of the denominator. It's going to soften the impact of injuries that you have when you do the calculation. So hourly workers, get that report from payroll, but make sure you add in salaried time as well. This is the 301 form I mentioned before. If you're doing the state first report of injury form, you don't have to keep the 301. 301 is actually a better form. It asks for additional information that I think is important from a safety standpoint. Multiple establishments. If you're a contractor and you're at a job site for more than a year, you do need a log at that job site that's going to be in operation for a year. The number of employee exemption, 10, we talked about, is determined by the company, not individual locations. You can maintain the logs and other information at one location, but be capable of providing that within the time frame OSHA provides you with. Don't have to keep it on site. Usually it's easier to do so. So let's talk about who are the covered employees. We haven't defined what an employee is yet. An employee is an executive, hourly, salary, seasonal, part-time, migrant worker, and here's the catch-all, all directly supervised workers. So this is kind of interesting. Thank you for bringing up temporary because it's a huge issue. If you use temporary employees in your operation and you provide day-to-day direction of those temp workers, their injuries are on your log, even though their injuries are not on your work comp policy. Big difference. You use temps, and a lot of companies use temps. Their injuries go on your OSHA log, even though you're not paying the comp claim. But for the reason that their injuries go on your log, their hours that they work also need to go on your log because hours are a good thing. The more hours you work, the more it softens the effect of the injuries that you have. So this just reiterates the point. And it's a big disconnect, and so many employers are not aware of this. So number one, you can get in big trouble with OSHA if you're not recording the injuries of directly supervised temps. The one exception to that, and we have seen clients that hire a temp service, but they also hire on-site supervision. If they have on-site supervision that's employed by the temp agency, then none of this applies. Their injuries don't count, and you wouldn't count their hours. But many companies use and directly supervise the temps. Their injuries and their hours are yours. Gets interesting because what if the temp agency is reporting the same injury that you're reporting? Now, there's no way that we can really audit the temp agency's records, and it's a potential problem that would actually overstate, excuse me, the injuries. All right, so on the 300A, the annual summary, if you use the Excel spreadsheet, all of the data that you enter is going to be carried over onto here. So we talked about the importance of hours worked by all employees. Another thing that happens is you'll notice on the form that it asks for somebody to sign and certify the log. Believe it or not, it's a requirement that the highest, I apologize, we did say this is going to 11:30? Okay. Which will be just about right. Depends on participation. Sometimes they go longer, sometimes they go shorter. Just say for free, we're giving you value, whether it goes shorter or longer. For anybody who's upset, we'll refund your price of admission. Anyway, one of the more common violations, believe it or not, is the highest ranking executive at that location is the one who has to sign the log. So if you have a safety director of a company for a facility that signs the log, and there's an operations director or VP that runs the plant, that's a violation. I've seen that citation issued. Why do you think they want the highest ranking official to sign the log? They see it. They want the highest ranking individual at the location to be aware of the incidents that are occurring. The problem is we're giving them raw data. We're not giving it to them in the context that they can make a decision, which is why it's going to be so important to calculate the rates that we're going to talk about in just a few minutes. So, yes?
So we have many locations. I'm at corporate, lots of locations. I have a bunch of these to go out for posting February 1st. But I was directed to have our CFO sign all of them.
That's interesting.
Is that okay?
Technically, it's not the highest, and so it's going to be a corporate person who signs the logs. I mean, I think I would come fight that for you at no cost if they issued a citation, but to be on the safe side, it really should be the CEO. Okay. Or it's location specific. You could have the CEO of the entire operation, multiple locations sign it, which would be fine, or you could have the highest ranking official at that location sign. But yeah, technically, it would be, I mean, I'd lose a lot more respect for OSHA if they did that, but the point is the person at the top of the food chain really needs to know. All right, this defines who that person is. It's really the highest ranking person at the location where a log is being maintained. Posting period, you have to keep the log up from February 1. That's why we do the workshop in January, and keep it in place until April 30th. You can keep it up the whole year if you want to. Back in the early days, we actually used to post the entire log. At Texas Instruments facility where I was safety director, we had 2,000 employees, and we would post the log in a common area with the names on it. And there was kind of a reason for that. Remember I talked about, and here I am criticizing OSHA for shaming companies, right? And here I am now saying that but it was a disincentive. I mean, if you were an employee, you didn't want the hall of shame, so maybe you'd think a little bit more before you did something. You know, 90% of all accidents are the result of an unsafe behavior. And sometimes the unsafe behavior is not the fault of the employee. If we haven't done our job training and reinforcing, it's our fault. If you have rules that are being broken on a daily basis and somebody gets hurt, in my opinion, that's not the employee's fault. That's our fault because we've allowed it to happen. But human behavior is probably the most important element of safety these days. I mean, it's a technical subject, but behavior is huge. Anyway, you could, if you wanted to these days, put the log up, but just white out the names of the individuals. It's easier just to put the summary up. Retention. So, your logs. This is interesting because I've had this question before. Some people participating in the workshop today may be filling out the log for the first time. Well, if OSHA came in and you had 10 injuries that you told the compliance officer you were going to put on the log on January 1st, you're in violation. If OSHA walks in, they want to see a current log, it must be kept current within 7 business days of your knowledge of an event. So that log needs to be kept current. So as things occur, record it on the log. You can always take them off. You could always remove it from that spreadsheet. OSHA will expect you to have 5 years of completed logs. They can. Typically, they ask for 3. But they could ask you to go back 5 years, full calendar years, plus the current year. Beyond 5 years, you can throw them away, although why you would want to do that, I don't know. Electronic format obviously is acceptable. You are required to update logs from previous years if there are changes in the status to injuries on the log. So for example, somebody gets hurt on December 25th at work, and you're going to post the log in February, but this person still remains off work or on restrictions. You are required to go back and update the 2021 log at some point when all the dust has settled. The one thing you never want to do is to take an event that occurred in late December and record some of it on 2021 and the rest of it in 2022. You've just double counted something. So anything that happens always goes back to the year in which it happened. That could even happen. Somebody, I don't know what the statute is in Colorado for reporting a work comp claim. In Illinois, it was 45 days. But that means that if an employee in January came and said, oh, by the way, I'm just letting you know I got hurt in December, that doesn't go on the 2022 log. That goes back on the 2021 log. Change in ownership. Actually, OSHA requires the owners or sellers of the business to transfer the OSHA logs to the new business owner. So if there's acquisitions, that's an expectation that the seller would transfer that information. All right, electronic record keeping. So we've covered the logs, how the logs need to be maintained. There is another dimension for many of the participants in the workshop today that requires you to file this information electronically with OSHA. It's called the, I can't remember, they have nomenclature for it. You set up an account with OSHA specifically to report this electronically. The portal, I can't recall. At first, they differentiated. They had companies with more than 250 employees, and originally what they wanted those companies to do was to file specific data on each injury. Now, during the Trump administration, they scaled that back, and all they said is, we want the information from the 300A, not detail on each injury. That may change in the coming years under the Biden administration. And then the second group, which only was required to file the 300A, is establishments in high hazard industries, which pretty much includes anybody who's going to be participating today, with more than 20 but less than 250 employees. So electronic record keeping at the simplest level, if you have 20 or more employees in a high hazard industry, which is going to be anything in manufacturing and construction, you have to file this information electronically if you have more than 20 people. The only difference will be if they go back and they say, well, you're a company with more than 250, so we want to see the individual detail of each injury, which isn't in place now, but could be. So just heads up on that. Anyway, I mentioned this before, that state plan states all employers across the country report to one portal. If you're between 10 and 19 employees, then all you have to do is keep a paper log or electronic copy. You're not going to file electronically. So if you're one of the participants in the workshop today and you never have more than 20 employees at one time during the year, you don't have to file your OSHA information electronically, but you do have to keep a log. This information needs to be posted by March 2nd. Every year. Why they picked March 2nd, don't know. Could fall on a Sunday. They just arbitrarily picked March 2nd. And the other interesting thing is it doesn't allow you to enter data after the March 2nd deadline. So if you miss the filing deadline, you can't enter information in for the year. And because it's a regulation, if you were inspected and they said, well, you didn't file for 2021 by March 2nd, you could be issued a citation with penalties. So there's no late reporting because they won't allow you to do it. All right, as far as posting the form, all employees with more than 10 employees are required to post. Even though you're reporting electronically, still have to post that, unless you're in an industry which isn't required to keep records: retail, insurance, real estate. This is kind of interesting, but when they revised, when they issued the electronic record keeping, they did include some provisions that were never in the record keeping standard before. And these are what those are. So you are required as an employer to inform employees on what they need to do to report an injury. Now, from a safety perspective and a claims perspective, that should be part of your program anyway. I might suggest that you document that communication in the event that an employee called OSHA and said, nobody ever told me what to do. You can produce a document that said, my employer explained how to report a work comp claim or a work-related injury. You also have to tell employees that they have the right to report injuries and that you as the employer are prohibited from firing or discriminating for reporting a work-related injury. And this is because there are some employers, unfortunately, in this country that do exactly that. You know, if you get hurt, I'm going to fire you. Well, that's illegal. So with this standard, OSHA actually requires that you inform your employees of this. So my advice is if you have a safety program, written safety program, and you have a procedure on reporting accidents and injuries or in your employee handbook, that you spell these things out in your handbook to make sure that you can prove to OSHA that that was, in fact, communicated. There's another section, prohibition against discrimination. When they talk about discrimination, they're talking about discriminating against employees by discouraging them to report work-related injuries. The prohibited activities that right now are not in place, but may be back in place. Remember, this is kind of transitional right now. When they wrote the standard, this was included. And under the Trump administration, they backed off on some of these elements, but some of these elements may be enforced again. They will let us know. Part of our job at CCIG is to stay on top of this and to let you know through communications what's going on. But blanket post-injury drug testing was considered a discriminatory type activity unless you did it for cause. So if you're going to do a drug test, the criteria can't be the employee was hurt, that's good enough reason. It has to be something that you were suspicious of caused the employee to be hurt. Discipline for late reporting some injuries. So that one really hits home to me because Risk Management 101 is the prompt reporting of all injuries, no matter how minor. And one of the ways that we would enforce that is if an employee came to me and said, oh, by the way, I forgot to tell you, I amputated my finger a week ago. I would discipline the employee. I'm sorry you lost your finger, but are you nuts? You're waiting a week to tell me? Well, according to OSHA, if they put this back in place again, you could be in trouble by disciplining employees for reporting an injury late. The only way we can manage prompt reporting is to hold people accountable. So we'll see where this goes. I laugh at this one. So disciplining employees for safety violations primarily after an injury occurs. Now, that one I agree with. That's a discriminatory activity. So I've had employers tell me, if I ask, because accountability is so important in a safety program, do you hold your employees accountable for safety violations that result in an injury? And the answer they give me is, oh yeah, especially after an accident. It's like, okay, so you're observing violations, but you're only holding the employee accountable when they get hurt. Yep. Well, how about when you identify the violation before an injury, you actually address that with the employee? So the point is, we'd be far better off to approach employees about unsafe behaviors long before the injury occurs. So I actually agree with that. And safety incentive programs, we're not having an injury as part of the program. I also think that those could be better set up. And sometimes you're rewarding people for blind luck. They did the wrong thing, just got away with it. I mean, the fact is you can do the wrong thing and get away with it most of the time. It's called the accident pyramid, something else I talk about. Anyway, so I already beat this to death. Fatality and catastrophe reporting. Let's quickly breeze through that. We have about 15 minutes to go. You, as an employer, are required to notify OSHA within 24 hours when one or more employees is inpatient hospitalized as a result of a work-related event. You're also required to notify OSHA within 24 hours after an employee suffers an amputation or loss of an eye. So 24 hours from the time you were notified of this result. With a fatality, timeframes are tighter, within 8 hours. So your obligation is to notify OSHA within 8 hours following the death of an employee. Now, this is interesting because weird situations come up. If the employee survives the original event but dies later, you're only obligated to call OSHA if that death occurred within 30 days of the incident. If the employee hangs on for 6 months and then dies, you're not obligated to report it by phone. That goes on the log, but not by phone. And the point that, well, I'm not sure what the point is, to be quite honest. It's strange. Now, hospitalization. If the hospitalization occurs within 24 hours of the incident, then you're required to, and what I'm talking about is picking up the phone or filing a report electronically notifying OSHA that you've had one of these events. All of these things are recordable. They go on the log. But if the employee who was injured on the job is hospitalized and it's beyond 24 hours from the date of the incident, you don't have to pick up the phone and call. Strange. Amputation includes, this is very interesting because now we get into work comp discussion. An amputation where bone is involved is always more significant than an amputation involving just skin without bone. OSHA doesn't care. And so I've asked the question, well, how much? If I lose 3 skin cells, do I have to pick up the phone and say I've amputated 3 skin cells? Like, where do you draw the line? But if somebody suffered an amputation, now this is really interesting, and this gets into detail that would be very important. An amputation is not an avulsion. So if somebody was working in a machine and it was a flap of skin that was still attached to the finger that was able to be pushed back into place and sutured closed, that's not an amputation because they kept, it never fully came off. An amputation implies that it's totally disconnected from your body. So if that avulsion can be sewn back on, even though it was significant, part of the fingertip, it's not an amputation. I also found this was really kind of amusing. So you have to report the loss of an eye. And loss of an eye does not mean blindness. So if you're blinded, but you actually keep the eye organ, that doesn't need to be reported to OSHA. The loss of an eye, presumably where you can't find the eye, because loss means, well, I can't find my eye. Well, I guess we better call OSHA. So it's kind of strange. You would think, and there's many ways you could be blinded and still keep the eye organ itself, but OSHA's really only concerned about the loss of the eye organ itself, which is kind of strange. I would caution you that if you fail to meet these reporting obligations, you could be inspected. OSHA gets calls from paramedics, from fire departments, from hospitals about work-related events. There's no mechanism in place. It's just people pick up the phone and call the agency and say, I think you should know. There was an occupational incident. There's been a hospitalization, amputation, whatever it might be. So if OSHA knocks on your door and says, did you have an amputation last week? If you have not reported it, there will likely be citations and penalties associated with that failure to report. And they will make examples, statements, by citing people for doing that. So understand there are other people that can call the agency when these things happen, and you need to stay on top of it. Reporting requirements like this keep the agency very busy. It's amazing. It used to only be death or hospitalization of 3 or more employees from the same occupational incident, which fortunately are very rare. Now that they've upped the ante 5-6 years ago with hospitalization, amputations, and eye injuries, loss of eye, it's keeping the agency very busy. Making notification, you can call your local area office, you can call a national number, or you can go on the website. I always believe you want to pick the method that buys you the most time. And the most time would be filing it on the internet. It goes to DC. From DC, somebody has to pick it up, send it to the local area office. You're not dodging responsibility, but the last thing you need in the middle of a bad situation is a compliance officer there within hours. You have stuff that you need to take care of. You know, I just give some helpful advice. If you have one of these reportable events, do what you can to control the scene. Obviously, get treatment for your injured employee. You have family notification. You got a lot of things to take care of in HR or in safety. And try to get some early information on what happened. That can be very helpful. So anyway, doing the online notification could buy you some time. BLS. BLS is another government agency that collects data, but they're not connected. In fact, I think we have a client on the call today who received a request from the Bureau of Labor Statistics for information on the OSHA log. The BLS is a statistical agency, Bureau of Labor Statistics. They have no connection to OSHA. The only trouble you could possibly get in is not responding to the request for information. Because when they send the information request out, it says response by law required. Bold, red font. So what they're doing is they're collecting the benchmark information that your experience will be compared against. They're the data collection agency for the Department of Labor. And it's a good thing because we need a reference point to compare our experience to. So, as we draw closer to conclusion, benchmarking is really important because it gives you have two, in my opinion, you have two statistics that you can look at to judge the success of your safety program. One is the experience mod. And if your experience mod is below 1, you're better than average. I've actually had some employers, I'm at a 0.98. I'm fine. Well, you could be at a 0.72, so why wouldn't you want to work a little bit harder to get down to the lower number? But it's just a different way people look at things. So the experience rating is one way of judging the success of your safety program. The other way is through the incident rate calculations that we're gonna get into here. And to be honest with you, when you ask the CEO of the company to sign the 300A log, you're giving them a piece of paper with a bunch of numbers on it that have no context. If we were really doing a good job, we would do the incident rate calculations, show what the same rates are for our peer group, and then explain it to the CEO and have them understand. Because they're the one that can affect change. Safety programs are driven from the top down. So we have 3 rates that we look at in safety. The first is the recordable incident rate. If it's on the log, and remember, we only want to put on the log what we have to put on the log. If it's on the log, it's a recordable event. Then we have a DART rate. And the DART rate is if you've checked the column for days away from work or restricted work activity, that is a DART. That is a DART event. And DART rates, what OSHA actually uses primarily in the site-specific targeting program to target your business for inspection. And then we have what's called the DAFWE rate. Days away from work, injury and illness is what DAFWE stands for. This would only be those events on the log that result in lost work days. The most serious type of event, other than death, obviously. So those are the 3 rates. Recordable incident rate, if it's on the log, it's a recordable event. We calculate the rate. DART rate, only those that result in restrictions or lost work days. DAFWE rate, only lost work days. Really easy way to calculate this. So the incident rate of recordables is, you'll see on the 300A form how many recordable events they are, multiply by 200,000. That represents the number of hours that would be worked by a company with 100 employees. And then divide that by the total number of hours worked. It's a rate. The rate means how many people in your company, for every 100 that you employ, how many people were hurt badly enough to be on the OSHA log? And if you're a very big firm, the biggest number should be recordable events, because then we have less restriction and lost workday cases and less even than lost workday cases only. The DART rate, same thing. Total the number of lost workday events, add it to the total number of restricted workday events, multiply by 200,000, divide by the total number of hours worked. And with the DAFWE rate, only the column that had lost workday events, add up all those events, multiply by 200,000, divide by hours worked. So the peer data is located on the BLS website, which you can get to through the OSHA website. The most current data is from 2019, and it's located in the link that I show in the slide here. We are going to be emailing the slide deck later, so you'll have this as a reference. So I don't know how well people participating virtually can see this, or even people in the audience, but this is what a report from the BLS looks like. So you'll need this as a reference so you can go back and do the calculations yourself. But for example, let's say that we have oilseed and grain farming. That's what you do. This is your NAICS code, and I would go back and make sure that your NAICS code represents the majority of work that your company does. Some companies are diverse and do many things, but if you have a core business, you want your NAICS code to match your core business. And these are the codes right here. So if you find the BLS website, you can scroll. They're grouped by manufacturing, construction, agriculture. Anyway, so oilseed and grain farming. The total recordable cases, the green arrow, is the incident rate of recordables. That's your benchmark rate. So you calculate what your rate is using the formulas that I showed you, And then you come back to the BLS website, you look for oilseed and grain farming, and if your rate is below a 2.9, you're doing better than your peer group. With your DART rate, this column here, this is kind of confusing. That's why I've color-coded it so you can look. It says cases with days away from work, job restrictions, or transfer. Total, the blue arrow, is both cases away from work and job transfer or restriction. They call that total. It's the DART rate. So for oilseed and grain farming, for every 100 employees, 1.7 are hurt badly enough that they either get restrictions or lose time from work. The last one, the DAFWE rate, is this here, the column that says cases with days away from work. So in oilseed and grain farming, for every 100 employees, 1.1 out of every 100 are hurt badly enough that they have to lose time from work. So this is the benchmark rate. Find your industry, and you can scroll and look at the descriptions. That will correspond to what your NAICS code should be and reflected on your 300A log. And then you calculate your own rates using the formula that I showed you, and then you compare it to these benchmark rates in the BLS form. Make sense? Again, if anyone has any questions, please reach out to me. I'd be happy to walk through this because it's important. Okay, as I mentioned before, safety is driven from the top down in organizations, so compare your incident rates to your peer group. If you're responsible for safety and you're below the peer rate, your peer group rate, tell the CEO with pride that your company is below the peer group rate and ask for a raise. Right? I mean, you obviously had something to do with it, so if you help the company perform better than average, it's all about getting money. If your rate happens to be above or worse than the peer group rate, I'd still ask for the raise and explain that you need support to improve the results. So I've got this working both ways in your favor if you have a responsibility for safety. So all kidding aside, which is on the slide, that's strange. That naturally, I don't know where that came from. Anyway, calculate those rates. That's important information. So many people participating today are well aware of the work comp experience modification rating. Important number to know. This is important data too. And it's a way of measuring yourself against a peer group. And I think it's important. You know, if you're in a dangerous injury industry, you're going to have more injuries than somebody in a white-collar business. There's no doubt about it. And it's just the way that it is. But you need to compare yourself against other people that do what you do. And trying to strive to be as good as possible, these numbers become important. So, common mistakes, not keeping the forms current. Remember, within 7 business days of your knowledge of one of these events, incorrect completion of the form, particularly the column F. You need to describe the injury or illness, okay? You need to describe the part of the body affected and the object or substance that made the person ill or injured. And I've actually seen this happen in one case. There was a description that was heat stroke, and it was one of those bad compliance officers that we don't want to deal with that issued the citation for heat stroke. He said it wasn't a complete description. Well, heat stroke is pretty understandable, right? He said, well, you didn't describe the part of the body that was affected. Seriously, this was a citation. We got it thrown out. Whole body. Okay, so heat stroke was the injury or illness, part of the body that was affected, and this was the really funny part. So we asked the compliance officer, well, what else do you want to know? He goes, well, you didn't identify what caused the heat stroke. And I said, you mean like the sun? And he said, yeah, you should put heat stroke, whole body, sun. I'm like, you're a goofball. You shouldn't have a badge. Take the man's badge away. Anyway, so you want to make sure, but I mean, and I've got some examples on here that are kind of silly, but hurt back, and these are things that I see all the time. People innocently just put a description that isn't complete. That can get you into trouble. Another trouble area is checking more than one of those boxes I explained before. And another issue is having days that are more than 180 totaled up on the form. Wrong person signs form, highest ranking official for a reason. And record keeping is important because it's a compliance obligation. Record keeping is important, in my opinion, more important because it provides you data. And if you live by the rules of what an OSHA recordable event is, and you actually track and monitor what your incident rates are, you're going to have a better grasp of your safety program. And again, I would discourage you from taking the approach, I can't really make the decision, so I'm going to put it on the log. I would prefer that you reach out to me and we can discuss these things, because I think you're hurting yourself by putting too many things on the log. You're penalizing yourself. It's information that the government is looking at. At some point, and I didn't mention this before, the intention when this was actually issued under the Obama administration was to make this data public. So if you're in construction and your general contractor is screening you to do work, it currently is not made available public, but the inspection history is, if you wanted to see if your company has been inspected or a competitor has been, you can go to the OSHA website and see how many inspections have occurred, public information. But injury and illness data, the plan was to make that public. And that may happen again. Currently it is not available. So you want the data that reflects your company to be accurate. So as far as the presentation today, that was a recent scan of mine. Explains I don't have as much to work with as some people. I try to make the best out of what I have. But in conclusion, this is a really important area. It's one that a lot of people don't pay much attention to, but for purposes of compliance, for purposes of your ability in some cases to work for general contractors and high-profile owners, this is important stuff. And it's important just so you know where your safety program is at. So hopefully you're leaving today with a little bit more information than what you came in with. If you've been doing this for a while, I'm sure some of this is repetitious, but with any luck, you walked out with a little bit more than what you walked in with, and I enjoyed working with all of you today. Davis, do we have any questions that weren't addressed?
We do. We've got 4 questions, all of which are from Jay. So first we have, each salaried employee caps at 2,000 hours. I'm not sure if that's...
Yes.
Okay.
Unless this...
Repeat the question.
Yes. Yeah, the question is, all salaried employees cap at 2,000 hours. That's generally been accepted to be a full work year for a salaried employee. If, and this would be the exception, you document the time, because I don't know the last time I worked a 40-hour week. I think that's a myth, a 40-hour work week, right? So if you're able to document that salaried employees work more than 2,000 hours a year, then you could use that documented number. But you have to have documentation.
Awesome. OSHA, do they discourage drug testing with an injury?
Well, they discourage drug testing if your only reason for doing the drug test is that the employee got hurt. That would be borderline discriminatory, preventing the employee from coming forward to report the injury. You would need to document something suspicious that may have contributed to the injury that would prompt the drug test.
Awesome, thank you. And we got 2 more. Pre-existing conditions. Can you create an indemnification policy to have new employees sign?
Pre-existing conditions, the question was, can you create some type of indemnification for pre-existing injuries. So some of that's going to cross over into workers' comp, and that would be above my pay grade to be able to answer from a work comp perspective. But I don't think that's going to be successful from an OSHA recordable standpoint. If an employee's pre-existing conditions were aggravated, you're going to have to eat the claim.
And you can't sign a waiver for workers' comp.
And there's no waiver for workers' comp. But one of our claims specialists at CCIG wanted to point out there's no way to dodge that bullet.
Okay, awesome. And then does self-inflicted injury equal intentional injury when it comes to recording? So,
Yeah, I mean, if intentional injury, I would think, would be self-inflicted, which would not be recordable and shouldn't be compensable either.
that's it.
Well, thanks to the people that joined us live. Thanks to the people that joined us virtually. I look forward to working with many of you, and by all means, I've already made the offer. Please reach out by email or phone. Get a hold of me, and my job is to help you. So 2.5 hours, I'm running out of voice, and thank you for joining, and have a safe day in snowy Colorado.